South Carolina lawmakers are debating how to protect your children in school without giving teens who act up an arrest record.
It's a bill to change the disturbing schools law. As Robert Kittle explains, some parents say the current law goes too far, while law enforcement says it's needed.
It was this incident at Spring Valley High in Columbia last fall that called attention to the disturbing schools law. School resource officer Ben Fields was called to a class because a student wouldn't put her cell phone away when asked. He ended up pulling her out of her desk and arresting her for disturbing schools. He was fired, but Columbia Representative Mia McLeod filed a bill to change the disturbing schools law. The sponsor of the bill says the law was passed decades ago to protect students and teachers from outside agitators, not student misbehavior, and her bill is to bring the law back to that. At a Statehouse hearing on her bill, supporters said the change is needed.
We think that matters of school discipline should remain school discipline matters and not matters that involve law enforcement.
But there is opposition to the bill by those who say the current law is needed.
I think we need to give positive reinforcement to the kids. That's why I taught when I was a teacher there. However, there's kids that will not obey the rules. And you've got to have, discretion for that officer or for that person.
Spartanburg Representative Eddie Talon read a statement from the State Sheriff's Association saying in some cases the current law is better for students in trouble.
The officer used the disturbing school statute as his means for arrest because it is a lesser offense than, say, disorderly conduct or assault and battery when fighting occurs.
The subcommittee put off a vote to work on amendments, and the bill is running out of time to pass this year. In Columbia, Robert Kittle, 7 News.
We checked with Richland County Sheriff Leon Lott about how deputies know when to use the disturbing schools law. He said that's the problem. It's too vague, and he thinks the law does need to be clarified.